We're going to start off with just a little talk about the First Amendment. So free speech is what we're here to really talk about. And the reason we picked free speech is because I don't know how many of you are paying attention to the news, but there's a whole lot of free speech news this year, from campus protests to schools to politicians to people criticizing politicians. And there's a whole lot of argument in the press and in the public sphere these days about what you can and can't say in America these days. What should you say? Where can you say it? Where can't you say it? So we thought the First Amendment, as it focuses on freedom of speech, would be a really great topic for 2017. For those of you who haven't gotten there yet, I'm just going to read the First Amendment so we all know where we are and what we're talking about. It says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or of abridging the freedom of speech, or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. That's the U.S. Constitution. New Hampshire has something similar. New Hampshire's Constitution was adopted in 1784, 5 years before that provision of the U.S. Constitution, and it has Article 22. So the New Hampshire's Constitution is broken down into two parts. The first part is a massive Bill of Rights, basically, and its free speech provision reads like this. Free speech and liberty of the press are essential to the security of freedom in a state. Just think about that for a second, because we're going to talk about that a lot. They ought, therefore, to be inviolably preserved. So that's how our constitutions address freedom of speech. We're going to start off with kind of a big question. I got some questions submitted from some students beforehand online. And this is a student question, and I think it's a great way to kick it off. Why was free speech put into the Constitution? So I'm going to turn to our professor here and just have us talk about that a little bit.
Okay. Well, one of the interesting things about the First Amendment and the provisions that it contains, the very famous rights that are embedded within the First Amendment, that were just ticked off: the right to free speech, the two religion rights, the right to freely exercise your religion and to be free from an establishment of religion by the government, the right to a free press, the right to assembly, the right to petition government. All of those rights were not in the original Constitution. The original Constitution that emerged from Philadelphia did not contain a Bill of Rights. And during the period of time when we, the people of the United States, decided whether we wanted to adopt that Constitution, a number of states said, we are only going to adopt that Constitution that you are proposing if a Bill of Rights is added. And that's how the First Amendment came to be. The Bill of Rights is 10 rights that were ratified in 1791. The reference to free speech in the First Amendment, notice it started with Congress shall make no law. And that reflects the fact that back when the United States Constitution was adopted, the Constitution only applied to and limited the federal government. And as was just explained, state governments were constituted and limited by their own state constitutions. Now, some 80 years after the founding, we of course fought a terrible civil war over the question of slavery and more generally the question of states' rights. And at the end of that war, one of the effects of that was the addition to the Constitution of 3 more constitutional amendments, one of which eventually made the right to free speech apply not only against the federal government, but against the states. And what I mean by when I say apply against, it means that your right to free speech cannot be taken away either by the federal government or agents of the federal government or by the states or agents of the states, people who work for the states. Most historians agree that the First Amendment, the free speech component of the First Amendment was put in there to really preserve freedom of speech with respect to conversations within government. We still haven't hit the 100th anniversary of the first Supreme Court case where the First Amendment was applied in a robust way to say that the government couldn't stop people from speaking. That didn't actually happen until the conclusion of the First World War. So The history of the First Amendment is tremendously interesting, and the history of our understanding of what free speech means has really evolved from a pretty limited understanding at the time of the founding to a rather broad understanding, the very broad understanding that we hold today.
Anything to add?
No, he summed it up. The professor summed it up brilliantly.
So for those of you who might think that we have the Bill of Rights is 10 amendments to the Constitution. The 10 Commandments were 10 commandments. People kind of think that the Bill of Rights were kind of handed down from on high. In fact, James Madison, who wrote them, drafted 19 to go before Congress, and people think, well, the First Amendment's first because it's the most important, but he actually had 2 amendments before the First Amendment that didn't get adopted by Congress. So the First Amendment came to the first because they said, no, these other 2 we don't want yet. One of them restricted congressmen's ability to raise their own pay, said Congress cannot pass a pay raise for Congress that goes into effect for that Congress. It has to go into effect in the future. And Congress said, oh no, we don't want to pass that. So they actually adopted that in 92? 92, yeah. So what would have been the Second Amendment became the 27th Amendment. It took that long to ratify.
I do have one comment, actually. I did want to note that, how Professor Greabe did say that the 14th Amendment has now been interpreted to apply the First Amendment to the states. Subsequent court decisions have made clear that also applies to municipal government bodies as well. So it's not just that the state of New Hampshire is bound by the First Amendment's protections. The city of Concord is, the Concord School Board is, the Manchester Board of Mayor and Aldermen are as well, et cetera. So that notion of incorporation, applying the First Amendment to the states, really has a trickle-down effect in applying to all government entities at the state or local level.
So James Madison drafted the First Amendment. His draft was not what we wound up with. His draft actually was a little bit different, and it called freedom of speech and freedom of the press one of the great bulwarks of liberty. And if you go back and read Madison and some of the other founders on this, to address the question of why do we have this, they believed very strongly that the ability to be critical of your government was a foundational part of being free. Like if you didn't have that freedom to criticize your government or to say, you know what, Parliament or the king or my state legislature, the colonial legislature at the time, they're not doing things right. We should do it this way. If you didn't have that freedom, they felt like you weren't really free at all. Like if the government could come arrest you for criticizing it, then how free would you really be? One of the cases before we had the Constitution, even before the United States, was in Massachusetts. And I just thought this was like a fun way to get you to understand. The first newspaper in New Hampshire was founded in Portsmouth by the New Hampshire Gazette by a guy named Daniel Fowle. And he wound up in New Hampshire because he had to flee Boston. Because a few years before, in 1754, he sold out of his bookshop. He wouldn't admit to printing it. There's still unknown who actually printed it. A pamphlet called The Monster of Monsters that criticized the legislature in Boston for, I believe the legislation was actually a tax on wine or something like that, but it criticized them and said they were all corrupt and they were all doing this for their own individual interests. And the legislature in Boston said, oh no, you can't do that. So they ordered him to be arrested. The actual language of the order is remarkable. It said, resolved that the pamphlet entitled Monster of Monsters is a false, scandalous libel, reflecting upon the proceedings of the House in general, and many worthy members in particular, in a breach of the privilege thereof, the privilege of the press, of being able to print things. Ordered that the pamphlet be burnt by the hands of the common hangman. How's that for dramatic? They actually had a hangman still, officially, in Boston in the 1750s. So this guy fled to New Hampshire because he was being persecuted in Boston. And so that's how New Hampshire's first newspaper got started. So that gives you a little bit of an idea of the dangers that you could be in in the colonial era in speaking and printing things. And I think that's sort of a good way to get going with this idea of the First Amendment protecting your ability to criticize the government. So I'd like to just sort of, we're going to break this down into a couple of sections and talk about, first, what sort of things can you say to criticize the government or government officials or people in authority? So I want to turn this over to Gilles for a second, just talk about that a little bit.
Sure. Well, you know, to echo what John and Drew have said, I mean, really the First Amendment was created because the founders really didn't trust themselves necessarily, right? They didn't trust the very government that they were about to create, and there was an intense fear, especially you know, after the Revolutionary War, and having themselves had deep skepticism of the royal government at the time, deep concern that that the government would abuse its power and censor speech, including speech that was critical of that government. And you know, we've seen, and John's right as well, I mean, the First Amendment really wasn't robustly interpreted, you know, the last 70, 80 years. It's really when we start seeing all these court decisions really making very clear that that is what the First Amendment means. That the government cannot suppress speech, peaceful speech based solely on its viewpoint. And there's some other restrictions as well, but that really is a principle that I think goes to what the First Amendment is all about. The government can't say, we're going to approve speech A, but we're going to disapprove of speech B. And you see that, you know, you see that with respect to unpopular speech as well. You know, there was a very famous protest of neo-Nazis in Skokie, Illinois, offensive speech, horrible speech that certainly I and our organization opposes, but there was a First Amendment right to do it. It was peaceful, and that's what the First Amendment really is all about at the end of the day, and that applies, of course, as well to speech that is hostile and critical of the government if it's done peacefully. The government can't suppress it and shouldn't be able to suppress it, because that, again, is, I think, fundamentally abhorrent to what the First Amendment is about. This notion that we have to allow controversial views, we have to allow critical views, because that's necessary to give, to create a marketplace where people can freely communicate. And without that, we really have a chilling effect on the ability of people to speak, because there it will be this inhibition, this fear, gosh, what if I say something that the government dislikes, that I will be suppressed, and I may even be prosecuted, and people have been prosecuted for the content of their speech. And so it's, I think, amazing to see, you know, we have, despite the First Amendment, have had efforts by the government to suppress speech that it doesn't like. Fortunately, the courts have stepped in and placed checks on the ability of the government to do it. So notwithstanding the First Amendment, there are still efforts to suppress speech, and we're constantly seeing, you know, lawyers and judges, you know, push back where appropriate.
So, so I'm technically a government official as chairman of the state school board. What can these kids say about me? If I do something they don't like, what sort of boundaries are there from a First Amendment issue?
Well, Drew, I'm sorry. The bad news is they can say just about anything they want.
Really?
Yeah, they do. They can. That would be protected speech. They can say things that are untrue, believe it or not, because as chair of the department of the school board, you are, or the Department of Ed, you are a public figure. And you are even less protected with respect to what things can be said about you than, you know, a regular member, you know, regular civilian, if you will. There are some limits on what you can say. I mean, the government can regulate speech a little bit. It can, it basically can never stop speech from occurring beforehand. Okay, that's known as a prior restraint on speech. And it is very well settled, you know, sort of the heart of the First Amendment is that prior restraints of speech violate the First Amendment.
So we were talking about prior restraints. That would be, give me an example of what a prior restraint would be.
Let's say that you understood that a local newspaper was going to be publishing a story critical of your office, and you thought that the story was based on a bunch of statements of fact that were not true. So you would try to go to court, maybe, and before that story comes out, get a court to issue an order saying the union leader or the monitor can't print that story, an injunction stopping them from publishing. That would be a prior restraint. And it is very well settled that that's not permitted, okay, a prior restraint of that sort. In fact, one of the most famous First Amendment cases that went to the Supreme Court involved the government trying to stop publication of information in the New York Times and the Washington Post about the Vietnam War that was leaked to the press in the 1970s. And the argument that the government made was a pretty compelling one. This information is incredibly secret. This information is crucial to our national security. People will die if you publish that information. That was the argument. And the Supreme Court said, we're not going to accept that argument. We're not going to trust the government in that way. We actually, at the time it was the New York Times, the Washington Post, we'll trust these papers to be careful about what they do, but at the heart of the First Amendment is the idea that government cannot restrain speech.
Have there been cases where the government has succeeded in saying, you know, this, in any prior restraint, like this information is absolutely, it's classified, it would endanger the public if they printed it?
If there have been, certainly not recently, not in recent history, not that I'm aware of. Now, again, though, as we talked about, you know, our First Amendment rights have really only fully flowered in the last 100 years or so. I mean, right after the First Amendment was adopted, again, it was adopted in 1791 as part of the Bill of Rights. Shortly after that, Congress passed a couple of federal statutes that are known as the Alien and Sedition Acts. These statutes were clearly unconstitutional. They clearly violated the First Amendment. And they were used by the party that was in power in the 1790s, the Federalist Party, to bring actual prosecutions against political opponents. And people were put in jail. So we didn't live up to the language of the First Amendment really throughout our history.
Yeah, and I think that's an important point. So if any of you are not familiar with this, John Adams, who was George Washington's vice president, John Adams was one of the great American revolutionary patriots. He, in Boston in the 1760s, was one of the leaders of the revolutionary movement. He was pushing for independence before a lot of other people were. You know, he was a hero of the idea that we needed to fight for our liberty. When he became president, he got so tired of the criticism from what were then called the Republicans, which was Thomas Jefferson and James Madison's party, that the Federalist Congress kind of talked him, and along with his wife Abigail, talked him into passing these Alien and Sedition Acts. The Sedition Act, and I have a little quote from it here. Now, keep in mind, this is 1798, so this is 7 years after the adoption of the First Amendment, which said Congress shall make no law abridging the freedom of speech of the press. The Sedition Act said it forbade, it outlawed any false, scandalous, or malicious, not and, but or, malicious writing or writings against the government of the United States with intent to defame or bring them into disrepute. So if you printed in your newspaper or spoke, even if you were a member of the government, if you spoke against President Adams or the part of the Federalist Party, you could be arrested. And in fact, John Lyons was a congressman from Vermont who was a Republican who spoke out against the Sedition Act and against the government. He was a sitting member of Congress who was arrested by federal agents and imprisoned for speaking against. So imagine, let's apply this to today, right? Imagine the Trump administration, just because that's what's in power right now, and the Republicans said, you cannot criticize President Trump, you cannot criticize the Republican Party, you cannot criticize anything the government does. And then they went and arrested Maggie Hassan for that's what it would be like. That actually happened in the late 1790s. And we didn't have this sort of First Amendment jurisprudence. We didn't have the law. And the Republicans said, my goodness, this is clearly unconstitutional. But there wasn't this idea that they could appeal to the Supreme Court. That sort of concept didn't really exist at the time. And so it led Jefferson to write the Virginia resolutions and the Kentucky resolutions, which we're getting down a rabbit hole, but which kind of gave this idea. Those said basically states don't have to abide by unconstitutional laws. And it started a whole mess. So that's the situation that we found ourselves in. The voters ultimately decided in the 1800 election by electing Jefferson and kicking out Adams. So we didn't have to go to the Supreme Court to settle that. They elected the Republicans and they repealed those laws. But that's the situation we were in the early 1900s, is that even then, even 7 years after the First Amendment, there was this concept that, well, really all that this First Amendment does is prevent prior restraint. After you say something, the government can come and punish you. And that was kind of up in the air for quite a long time in the 19th century. And it wasn't until the next Sedition Act in 1917 or 18, and during World War I, where Woodrow Wilson was trying to suppress speech critical of the government, that we actually had these first court cases.
That's right. And in fact, less than 100 years ago, a guy named Eugene Debs was put into prison for criticizing American involvement in World War I. He gave a speech where he expressed his view that it was folly for the United States to be involved in World War I. And he was put in prison. This was a guy, I have the number, 1 million. He received like 1 million votes for president. He was, might be somewhat loosely analogized to, I don't know if you've heard of Ralph Nader, third party candidate who ran for president, or even Bernie Sanders. This was a well-known national politician who was put in prison simply for expressing his view that participation in the war was not a good idea. So, again, most of our history, the First Amendment has not done the work that it now does in terms of protecting our right to speak out freely.
So the Sedition Act, we weren't at war at that point, the first one in 1790s, but in 1919, 1918, right, we were. So does the government have a greater ability to control speech or to suppress speech when we're at war? Is there, anybody want to take that?
Well, I'll get to that, but I think one of the things that Drew's just highlighting is the fact that First Amendment rights are not absolute. Even in the current First Amendment law, where it's been more robustly interpreted during the last 80 years. And so in every free speech case, and I know we're going to get into the weeds a little bit later, but a court is going to look at what speech is being suppressed, but in particular, what are the government reasons for why a particular speech should be oppressed. Now, I say 200 years ago, a court probably would have given maybe not, more deference to the government than I think our courts would give today, concerning, issues, like national security. Maybe not, though, however. When a government goes to a court and says, if we allow this speech to be engaged and it would impact national security, courts give pause. Courts are very concerned about these types of issues, and courts are going to balance the particular government rationale with the ability of balance the government rationale with the private speech interests involved. So sometimes the government succeeds, sometimes the government doesn't succeed, but often in those cases, usually a court's not going to take the government's word for it. The court's going to want some actual evidence to be presented by the government and demonstrating that if this speech is permitted, it would actually impact national security, hurt the ability of the government to prosecute a war, etc. So the government has a very high burden to meet, and I think courts would be skeptical and certainly require a significant amount of evidence to be presented in order to suppress the speech involved. I don't know if John could comment further.
Well, no, I agree. I think our history tells us that our civil liberties, which include speech, but not just speech, are restricted during times of war, and you'd expect that to be the case. The nation is more on edge. There's a mortal threat to citizens. Famously, during World War II, we rounded up and put into camps Japanese American citizens. And historians studying it have pretty conclusively shown that there was no evidence really of disloyalty from this group of citizens. but war breeds hysteria. And, Abraham Lincoln, many people would put at the top of our list of presidents. Abraham Lincoln suspended civil liberties and put in jail people who criticized what the government was doing during the Civil War. So I think the lessons of history are that our civil liberties, in fact, whether or not they should, it's not like there's no doctrine out there necessarily saying that our civil liberties shrink during times of war. But at the end of the day, judges recognize what they know and what they don't know and tend to defer to our politicians during times of emergency.
Yeah, and query whether that's a good or bad thing, right? I mean, when you look at the cases, that's certainly been the case where courts, courts are citizens like us. I mean, they're worried in times of crisis, as we all are, and there has been more deference given sometimes by courts in those times of crisis. The Korematsu decision that John Greabe just mentioned, was widely viewed as probably one of the worst Supreme Court decisions, where the court actually upheld and said it was permissible for the internment to happen, precisely because the United States was in a time of war. So these are hard questions in moments of crisis.
So is there a difference between when we're at, say, a declared war, World War I, World War II, where the entire country is mobilized, we have a draft? Technically, we're at war now. We still have troops in Afghanistan. So are there cases, are there examples from wartime where we can say, look, people, here's kind of the line, right? You can criticize the war policy, but what would be an example of something that the courts have maybe said, okay, this, when we're at war, this is not okay maybe for you to say, or this is where the government may have a little bit more power?
Well, I'd go back to the World War I cases, and in the 1950s, when the Cold War really emerged, when the Soviet Union came into possession of nuclear weapons. That was a time as well where there were prosecutions brought under various laws called the Espionage Act, the Sedition Act that was mentioned before. There's the theoretical, statement that you get from the court about what your rights are, but you need to recognize that for a case to get to the Supreme Court and for the Supreme Court to lay down a rule, there are many years take place, as the case makes its way through the system. And for every situation where somebody has gone to the Supreme Court and vindicated their free speech rights, there are hundreds and thousands of examples of actions being taken on the ground that are never challenged in court. I would also draw a distinction between civilians and the military. Within the military, you don't have a right to free speech like civilians do. And one of the things we've struggled with at times too is, well, where do we draw the line between the military and civilian court? I just saw in the paper the other day that for the first time in a decade, an American citizen has been arrested and declared to be an enemy combatant, and is, at least for now, being put into a system where that individual is not going to have access to a lawyer, is not going to have access to all the constitutional rights that go along with being charged with a crime within our civilian system. And so again, it's because we are at war, right? We are in an undeclared war that we've been in really since 2001 against terrorists. And the argument that the president will be making, or not the president himself, but the executive branch, is that this person has really effectively renounced his citizenship, taken up arms against the United States. He should be treated like a prisoner of war, not like an American citizen. So that's something that we also struggle with and need to work out.
So that leads to a really interesting question. Does the First Amendment apply to non-citizens who are in the United States? If you're not a citizen, but you're a foreigner and you're visiting here, or you're an illegal immigrant, whatever, and you say things that are critical, do you have First Amendment rights?
What do the cases say, John?
Yes, you do. Yes, you do. The 14th Amendment, which is what we talked about before, that was adopted following the Civil War, and that's the vehicle by which the First Amendment protects us against the states and all of their subdivisions, like counties and cities and towns. that the Fourth Amendment protects any person, okay? So the constitutional rights protected by the 14th Amendment, the right to equal protection of the laws, the right to freely speak, the right to freely practice one's religion, that applies to everybody within the power, within the jurisdiction of the United States.
Yeah, no, that's exactly right. So, you know, a non-citizen going through the criminal justice system being charged with a crime would still be entitled to all his or her rights under the Fourth, Fifth, and Sixth Amendments. And the same goes for the First Amendment. So it applies to all persons regardless of one's status in the United States.
So you're saying that our rights conceptually under the Constitution are inherent in our personhood, not in our status as a citizen.
Yeah, I think that's right. I don't think, you know, it would be permissible, say, for the state of New Hampshire to say, you know, only non-citizens or non-citizens are prohibited from criticizing the government, for example. That would not be a permissible restriction under the First Amendment.
There are some constitutional rights that are held only by citizens. The right to vote, for example,
Yep,
which is a
that's
qualified constitutional right. But basic civil liberties protected by the Bill of Rights are held by everybody against the United States government everywhere the United States government exercises jurisdiction, which is, you know, it's not just the territory of the United States, by the way. So wherever the United States government acts, there's at least an argument that the Constitution protects you and that the United States government needs to act within the confines of the Constitution. That's actually a really tricky issue, and that's a contested issue. But that's basically the case.
So at this point, I think we'd like to open it up for some questions on criticizing the government. It's not just about criticizing the government. So you have free speech, but there are some boundaries in what you say about other people, not just about the government. And that's one that I think has a lot of controversy right now. So I'd like to open this up to talking about what you can say or can't say about that person sitting next to you, or about somebody across the room, or about another individual, right? So think about that. If there's somebody in this room that you maybe, or in your life, that you disagree with a lot, or that you don't like, right? That's a different part of the First Amendment, a different set of laws, case law. Boy, that got him talking.
That got him riled up. Do you want me to chime in?
Yeah. So we're going to talk about that. So, and we'll take questions on that as well. But
this is everyone's excited about this.
That's the way we like to criticize each other.
As you should. And I think this goes to, I kind of touched upon it, you know, before. Speech that is offensive is protected under the First Amendment, you know, and, you know, when I'm talking about offensive speech, I'm talking about peaceful offensive speech. And it really has to be protected in order for the First Amendment to have breathing space to survive. And it goes part and parcel with the notion that unpopular speech is protected under the First Amendment. I mean, if offensive speech wasn't protected, you know, there would be this ever-present concern about what is and what isn't offensive. Who gets to decide? The government? It's a concerning notion in my view, and which is why the courts have said essentially, you know, you don't have a right to not be offended. Part of living in a free society means you are going to come across from time to time speech that you abhor, speech that personally offends you. But the First Amendment prohibits the government from going in and suppressing that speech because of its particular viewpoint. And so it's, I really think, a really important idea, and it goes, again, part and parcel with this notion that viewpoint discrimination really is something that's abhorred under the First Amendment. So I don't think the government, I'm sorry.
Well, just what does that mean, viewpoint discrimination?
Great question. So the government couldn't say, I don't think, you know, we're going to allow speech that's in favor of the Democratic Party or that supports the Democratic Party, but you can't engage in speech that is, you know, in opposition to or that supports the Republican Party. That's a viewpoint-based distinction, right? Democratic political speech, okay. Republican speech, not okay. So that would be something that, of course, would be roundly condemned by the courts. It would be impermissible. So when I'm talking about viewpoint discrimination, that's correct. That's what I'm referring to.
But that goes beyond, just to keep this wrong, so, but you're talking about political figures, but what if we were to say, you know,
I have another
Gosh,
example.
yeah, exactly. Go, let's hear another
How about
example.
this one? So New Hampshire passed a law about, it was actually a regulation 10 years ago that banned license plate speech that was, quote, offensive to good taste, something like that, right? That's effectively viewpoint-based, right? What is and what is not offensive to good taste? There's multiple problems with this, right? Number one, you're having government officials ultimately make this decision, which leads to arbitrary and discriminatory enforcement. But in addition, some speech that's viewed as offensive is not going to be permitted. Speech that's viewed as not being offensive, not crossing that line, is going to ultimately be allowed. I mean, that really, to me, is the textbook definition of viewpoint discrimination. Another law that I saw recently bans license plate speech that is hateful of religion. So if you have speech on a license plate that says, I hate God, that would be prohibited. But if you had speech that said, I love God on that license plate, that would be allowed. That is, to me, the textbook definition of viewpoint discrimination. And that goes for all other categories. If the government is starting to draw lines solely based on viewpoint, really courts are going to step in almost always and say they can't do it.
So viewpoint would be your point of view, right? So it can't say, well, we approve that point of view, but this point of view is not allowed, right?
Yeah.
So, but doesn't that open it up to really a lot of hurt feelings? I mean, don't you have a right to go out in the public and not have somebody say hurtful things about you or a group that you belong to?
You don't have that right. Actually, it's just part of living in a free society, is this notion that you're going to come across speech that is really hurtful and offensive. There are some limitations. I mean, here what I'm talking about is peaceful speech that's offensive. Violence, of course, not only is violence not speech, it's not protected, right, under the First Amendment. So there are lines that courts draw. Courts have also drawn lines with respect to speech that is likely to incite immediate violence. There are some exceptions under the First Amendment for what are called fighting words and incitement to imminent violence. They're very narrow exceptions. In fact, I think, courts don't frequently invoke them out of fear that they will create a chilling effect on speech. Because when people don't know where the line is on speech, they chill themselves. And so courts are really hesitant to, set standards that will create this sense of uncertainty among speakers.
So we just had it was a national news story, a speaker at the University of California, Berkeley this week, and students came out and protested him. They didn't want the university to allow him to speak because they chanted, and there was actually a video last night of students at the university chanting, "Speech is violence." Is that right or wrong? Is under the law, under the First Amendment, can you make that case that saying something that upsets somebody is the equivalent of violence, or is there case law that says, no, you actually have to be violent for it to be violence?
The case law is that speech is not violence if it's truly speech. Now, speech, it overstates it to say that all speech is always protected everywhere, right? I mean, I can't threaten you. So if I threaten you and put you in fear of your safety, that's a threat. The law treats that as conduct, and you could be punished for that. Although it has to be a very real threat, and the Supreme Court's made that clear.
So what is that? I want to make this clear for kids, right? So there's a difference between you saying something that makes me feel threatened or makes me feel unsafe, and you directly threatening me. Is that what you're saying?
Yeah, and like many things in the law, that can be a very, very difficult line to draw. There was this case that went to the Supreme Court a couple years ago that it's actually really interesting. A guy wrote violent rap lyrics about a woman that I don't know if they were married or not, but somebody he had been dating, and posted them on Facebook. And she understood these lyrics to be a threat to her safety, and went to the authorities, and the authorities actually brought a prosecution against this person for threatening, terrorizing this woman. The case went to the Supreme Court, and the Supreme Court threw the conviction out and said that the jury had been instructed in such a way as to permit it to find that he had engaged in a crime when, in fact, all he had been doing is engaging in speech that, I don't think many people think has a lot of value, but nonetheless speech. And so the Supreme Court made it very, very difficult, made it very, very clear that in order to convict somebody of a crime for threatening somebody else, that person had to have subjectively in his head intended it to be a threat. So there's a really, really wide range of protection for speech that we may find offensive, that we may find very, very upsetting. I'd actually, if I can return, I grew up a couple of miles from Skokie. Yeah. You had mentioned this. This was in the 1970s when I was in high school. One thing about Skokie, Illinois, where the Nazis held their march in the 1970s. Skokie, Illinois was a place where it was a very Jewish town, and it had the highest concentration of people who had survived the Holocaust were living in Skokie. And back in the 1970s, there were still many, many people who had been in camps in Nazi Germany. And so it was the height of provocation for the Nazis to want to hold a march in Skokie, Illinois. This case went through the court system. It was much watched, even as a high school kid. I remember this. And you know what happened? Ultimately, the right to march was upheld, and the Nazis held their march in Skokie, Illinois, and nobody showed up. Everybody just closed up their doors, closed up their windows. They marched through empty streets, and the issue went away. And that's, under one view, how our First Amendment is supposed to work. You are supposed to counter speech that you find hateful with your own speech, or you are supposed to ignore it. Now, in reality, many people say that's really, really hard to do, and a lot of people in this country have had very difficult experiences. That's a very, very lively debate, and there are some people who would say that we protect speech too much, that we ought not to protect hateful speech, hate speech. But the fact is, right now, under the law, hateful speech is protected. There are some limits. You had asked before about what people could say about each other as private individuals. You cannot say false things about private individuals without at least facing the possibility of a lawsuit for defamation. All right. So if you are saying false things or printing false things about your neighbor, and your neighbor can prove that those are false things that harm his or her reputation, your neighbor can sue you and maybe recover money damages. But it's very, very different, again, but that's because your neighbor is a private individual, not well known. We create a lot more space with respect to public figures, and that's why we allow things to be said about the president that are not true. Any president, I don't mean this president, but the press can print things that are untrue. And there's nothing, our system says the cure for this would be worse than the disease.
So if I were to say Principal Sicca is a closet 21 Pilots fan, that where would that fall?
One of the funny things is it's off again. Is Principal Sicca a public figure? Yeah. And in this community, I would say you're a public figure, and you probably have to put up with that.
What if I said Gilles smells like a camel? He's not really
a public figure.
He's not. I don't know that he's really a public figure, but that's not.
And that's also an opinion. And an opinion is not defamatory. A false statement of fact. If you say my neighbor is a sex offender, you know, something like that. That's the sort of thing where your neighbor can sue you for defamation if that's not true. But if you say, in my opinion, my neighbor is a you know, a crazy old bat, you know, that is protected, even though hateful, even though offensive, even though potentially very, very hurtful.
There are cases that are continuing to test these limits, even in public figure defamation cases. The mayor of Manchester has a lawsuit right now against a series of individuals who were petitioning the school board, and the mayor's alleging that they constituted false statements about him. So it's going to be curious to see how that case sorts out, because you know, that's an incredibly high standard for a public official to meet, to allege defamation.
How much power does a school official have to regulate freedom of speech in a school environment?
Great question. So you want to comment? Yeah, why don't you take that?
Sure. And this is, I'd be curious to get John's thoughts as well. He's much more well versed in the cases, but generally, you know, we talked before about how First Amendment rights are not absolute, and it depends on multiple factors. Well, one of the factors is, where is the speech taking place? If the speech is taking place on a sidewalk or in public, you know, courts are going to look at that type of speech restriction with more skepticism. But speech in a school is different. Right? And it's different because there's a whole set of different governmental interests that are now implicated. And those governmental interests are, you know, the desire, legitimate one, by the way, I think, to maintain an orderly school environment so education could occur, to minimize disruption, etc. But that does not mean that when students walk into the schoolhouse door, so to speak, that they check all of their First Amendment rights at the door. And courts have actually really struggled with this distinction about, you know, how do First Amendment rights work in a school environment. And generally, what the courts have said is a school can restrict the ability of students to engage in speech that is likely to cause a disruption to the school environment. And the key case where this was addressed is a case called Tinker versus Des Moines. And it's a case that actually comes from the Vietnam War. Interestingly, we were talking a lot about how these things intersect with times of crisis, these free speech questions. This case is one of them, where there was a series of students who objected to the Vietnam War and were going to wear and wanted to wear black armbands. And the school objected to that. And ultimately, the court concluded that you know, the speech was permissible. I believe the court said there really wasn't enough of a disruption justification here to permit the school from restricting speech. Subsequently, there was a decision called Morris versus Frederick, which is from about 10 years ago, which had to do with speech occurring outside of school, but during a school kind of event, where someone was displaying a banner called "Bong Hits for Jesus." I don't know if anyone is familiar with this case. And there, the school, but I think that highlights some of the important issues that come out of the Tinker decision. There, the student was disciplined, and the Supreme Court said that discipline was appropriate for various reasons, including the fact that though the speech was occurring outside of school property, it was occurring at a school event, number one. And number two, schools have a really, this is the court talking, and it's not unreasonable to some extent, schools have a really good reason to try to prohibit or control the messaging around drug use, and to foster an environment where where students aren't encouraged to take drugs. And so, you know, those are kind of a couple of seminal decisions in this area, but key really is there an actual disruption? Can the school show that the speech in question that they want to suppress is likely to disrupt the educational environment?
And you're juniors and seniors, is that right? Okay.
Oh, and some who aren't.
Oh, okay, some who aren't. But one of the things that you should know is that your First Amendment rights in a public school setting are going to greatly expand as you move from high school to if you go to a public university, if you go to college, and if you go to a public school. Again, First Amendment only applies against public institutions. All right, so if you go to a private school, the First Amendment does not give you any rights. So yes, I think what Gilles said is exactly right. In a high school setting, the officials have fairly extensive latitude to maintain a proper educational environment and to protect students. And we recognize that things are different when people are younger. As you move into a university setting, however, the First Amendment applies with much greater force, and that's why in the case from Berkeley that you were talking about from the University of California at Berkeley, you know, those people who would like to shut down speech with which they disagree are unlikely to succeed, you know, at least certainly if the matter makes its way into a court.
But if that student wanted to speak at Harvard, which is a private school, and Harvard could then say, no, sorry, we're a private institution, we get to decide what's said on our campus. Right?
Yeah, I don't know if you, I mean, in the news in the last couple of days, Harvard Kennedy School of Government actually extended an invitation to Chelsea Manning to participate on the faculty or as a faculty fellow. That engendered a lot of controversy and a couple of resignations, and I saw today that Harvard withdrew that invitation. Now, if Harvard were a public school, arguably, I mean, it's, you know, these things can be tricky, but the calculus would be different. It might be a little bit more complicated for Harvard to uninvite somebody, you know, if it were subject to First Amendment constraints.
Yeah, private institutions, again, as John said, are not subject to the First Amendment, Harvard, Brown University, you name it. That doesn't mean that it wouldn't be bad policy for those institutions, certainly to engage in viewpoint discrimination, but that distinction is really a critical one. You know, private institutions aren't subject to the First Amendment, but that doesn't mean there isn't a tremendous amount of advocacy done to try to ensure that even private institutions maintain an environment that's speech protected.
So what you're saying is, you know, the government can't tell me that I can't say something, but the Concord Monitor is not obligated to print my letter to the editor, because that's a private newspaper.
Yeah.
Gotcha.
Yep.
We have another question.
What's the best way to protest a school environment while, of course, still being respectful and hopefully getting results?
Within the confines of the First Amendment, the best way to engage in speech that's not likely to cause a disruption or will be viewed as causing a disruption would be to engage in speech at home about school, outside of school premises. You know, there's going to be much greater First Amendment protections than if you were engaging in, say, speech critical of school officials on campus during school hours. A good example that's interesting, and it never resulted in litigation, sorry, I forgot to turn it off. A good example would be about 2 years ago, I can't remember the town in New Hampshire, there was a lot of snow. I know because I was in Henniker and I couldn't make my way into Concord that particular day. But this particular school decided we're going to have classes, and a lot of students were very upset by this, and took to Twitter and said things. I still don't know exactly what the tweets were because they were since deleted, but said things that were very critical, in fact, of the superintendent. Ultimately, the superintendent's decision to not cancel school, I'm guessing there was some colorful language probably in those tweets as well. And ultimately, there was a disciplinary decision taken against the students. And it raised really interesting questions because you're dealing with speech there that took place not while school is in session. It's taking place online while that student, you know, is at home. There's going to be greater First Amendment protections there than if that speech, say, occurred, you know, in the middle of assembly like this. So those are kind of where some of the lines can be drawn. There's tons of gray in all of this, and I'm not even saying that the speech was protected in this particular anecdote, but it would be more likely to be protected than, say, speech protesting school activities occurring in a school environment, you know, during school hours.
One of the things I think you used the word respectful or something to that effect, and that's actually key, right, to staying within bounds. Just because you have the right to say certain things doesn't mean you should, doesn't mean it's a good idea. If you're trying to persuade, if you're trying to protest, like what's the result, what's the goal of a protest? Right? There tend to be two different goals, I think, of protests. One is just to get attention and to raise an issue, right? Nobody else is talking about this, so we're going to go out and talk about it, we're going to pick it, we're going to get people's attention so that they know what we feel. There's another goal of protests, and that would be to actually change the policy, right? So your goal is to persuade people to go from one point of view to the other point of view, right? So there are different tactics that you might think about using. If your goal is to just get attention, than if your goal is actually to persuade somebody. If you're trying to persuade somebody to adopt your point of view, it's typically a good idea not to insult them and not to attack or belittle. So just think about these sorts of things, and we find that, whether that's in a school setting or in the legislature or in the broader public sphere, being respectful of the other person's opinions and adopting an approach that basically communicates to that other person, look, I understand your point of view. I don't agree with your point of view. Here's my point of view, and I think you should come here. That tends to work really well. At least you get them to understand your point of view better than just saying, you're a jerk for thinking what you think. So there are different ways to go about getting your point across. So we're going to go to some student questions that we have submitted. If anybody else has a question, feel free to raise your hand and come on down. This is a question that we got from a student emailed. Do certain groups of people have more free speech than others?
Do certain groups have more free speech than others? Well, I think the way that I would spin it, it's not so much who's speaking, it's the type of speech that's engaged in. So if you're engaging as a citizen, or anyone for that matter, in political speech, courts are incredibly concerned about restricting political speech for all the reasons that we talked about before. So I think it's less about, in my view, the group of persons engaging in the speech, because courts don't want to discriminate based on speakers, right? Courts want to think about what are the speech interests, free speech interests implicated, the type of speech involved, and what are the governmental interests in potentially suppressing it. So I think the way to think about it is, what type of speech are we talking about? And if we're talking about political speech, addressing issues of public concern, it doesn't have to actually be political speech. There could be types of speech that are non-political, but that are dealing with issues that are of public import, that are in the newspaper, et cetera. Courts are really going to step back and say, wait a second, I need to be really careful here about trampling upon First Amendment rights. That doesn't mean the court will ultimately not agree with the government, but the courts are going to be very concerned in that particular setting.
We have a question over here.
I didn't know if you heard about the Red Sox game banner that was put up. I was wondering what your stance was on that, and if it had said something else, if it would have been treated differently.
Good question. Well,
Great question.
So Fenway Park is a private facility. It is not a government facility. So it's owned by the Red Sox. That makes a difference, does it not? Right?
It does. On the back of your ticket, when you go to a Red Sox game, it actually reserves the right to the team to bar people, to eject people from the stadium for engaging in what they regard to be, antisocial, disruptive behavior, and actually you can be barred for a lifetime. It's one of the things that was interesting about that banner is I saw that the other night, and my first reaction as to what it was oh my goodness, this is a banner being unfurled by racists who are sort of asserting that racism is properly and deeply embedded in American culture. The next day, I learned that wasn't what the message was intended to be behind that banner, and that's another really interesting thing too. Is how speech and expressive conduct can be, how there can be a disconnect between what the speaker intends to be saying and what the audience intends to hear. But it's absolutely right that with respect to that incident, there are really no First Amendment implications, and the Red Sox can take action to bar those people from coming back to Fenway if the team so chooses.
Yeah, choose your words carefully, because sometimes the message you think you're sending is not what people hear. We have another question.
I was wondering where the First Amendment came in at presidential rallies with protesters.
So again, it really depends on where the speech is occurring. So if the speech is occurring, for example, indoors at St. Anselm's College in Manchester, free speech issues may not apply at all. The First Amendment may not apply because you're dealing with a public forum. You're dealing with an event that very well, or excuse me, you're not dealing with a public forum necessarily. You're dealing with private space being run by a private institution. That private institution can impose whatever restrictions they want on the ability of outsiders to come in, because again, the First Amendment doesn't apply. The rules would be fundamentally different at, say, UNH or Keene State College. There are still some interesting issues there with respect to public universities. There are some questions about what latitude a public university would have to regulate speech, given that they have a distinct and unique educational mission, say, as opposed to a speech held at a park, White Park here in Concord, for example. But still, I think it's fair to say if you're dealing with a public place, the government is going to have far less latitude, and there's going to, counter-protesters can engage in speech so long as they're, in a public place and acting peacefully. So it's really going to depend as to where the speech is occurring.
So we have a submitted question that's also relevant and timely. Given the recent events in Charlottesville, Virginia, is freedom of speech still a good thing? Anybody want to tackle that?
Well, that's, that ties right into what you talked about with respect to, what was happening in Berkeley. There is a very lively debate right now, and has been for a while, about whether or not hateful speech should be tolerated. There are many people who say that the First Amendment overprotects hate speech. You've heard that term hate speech probably, right? And some people think that hate speech is unprotected. In fact, it's not a category under First Amendment law like defamation is. There are certain categories of speech where greater regulation can take place, obscenity, defamation. Hate speech is not one of those categories. And there are people who say, especially given our history of racism and other unfortunate but undeniable facts of American history, that we need to re-examine whether or not we do tolerate words that are very, very hurtful to people. What we've been telling you is the state of the law as it is right now. But one of the cool things about our system is that the law never is. It's never frozen in time forever. The law is always about to be. The law is always unfolding. And for those who believe that too much hurtful speech is protected, our system can accommodate that viewpoint. And if a sufficient number of people can be persuaded, perhaps the law will change a little bit.
Oh, there we go. You guys were great. Thank you.
Thank you.